I'll also ask you to bear in mind that the people on the panel weren't the people who necessarily created the entities. They fill roles on the entities, but they weren't responsible for their establishment. But certainly they would welcome your feedback, your questions towards that end. I was particularly delighted this morning to have the opportunity to listen to my friend Greg Christie and his presentation, and to hear from him, as I had heard from Dr. Trevor Monroe on the radio a few mornings ago, of the recent tabling late last week in the Jamaican Senate of a bill to amalgamate, I think it's 3 existing anti-corruption agencies, something that I know Greg had been advocating for a number of years. And I say that simply to say that we must consistently be examining whether there is the need for or the merit in us continuing to do things the way we're currently doing them, or whether there is need for us to adjust and change. But that's enough from me. Let me introduce you to our panelists this evening, representing these institutions supporting democracy. On my immediate left is Mr. John Liebers, representing the Office of the Information Commissioner. Mr. Leonard Ebanks, representing the Anti-Corruption Commission. Mr. Alistair Walters, representing the Human Rights Commission. Mr. Alistair Swarbrick, representing the Office of the Auditor General. Mr. Will Pinot, representing the Constitutional Commission. And I am pleased to see, having slipped in and not got marked as being late or absent. I know you were in an earlier session, Nicola. Ms. Nicola Williams, representing the Office of the Complaints Commissioner. We will hear from each in that order, and I will now call on Jan to start us off.
Thank you very much, Mr. Chairman. Mr. Chairman, members of the panel, ladies and gentlemen, I'm here to talk to you about the Cayman Islands Freedom of Information Law. Access to information is increasingly seen as a fundamental human right. The European Court of Human Rights, the United Nations are moving into the direction of recognizing access to information not only as a sort of amalgam or a flip side to the freedom of expression, but in its own right, access to information is becoming a fundamental right. This morning, Mr. Gulsaran from Transparency International in Guyana said that democracy and accountability are 2 sides of the same coin. And that very idea is actually worded in the statement of objects in our Freedom of Information law in the Cayman Islands. And I'm just going to read that for you. It's the only part of the law that I will read verbatim, but I think it's an important statement. The object of the law. The object of this law are to reinforce and give further effect to certain fundamental principles underlying the system of constitutional democracy, namely A, governmental accountability, B, transparency, and C, public participation in national decision-making. By granting to the public a general right of access to records held by public authorities, subject to exemptions which balance that right against the public interest in exempting from disclosure governmental, commercial, or personal information. So what it does is it establishes a general right of access to records, and I'm going to come back to that, not to information, but to records, held by public authorities in the Cayman Islands public sector. And that means that really people can ask for any of the information held. Doesn't mean they're going to get it because, as this statement says, that general right is balanced against a number of exemptions. There's also a few exclusions. For instance, the courts are entirely excluded, or the judicial functions of the courts are excluded. And that's the very balance that also Huguette Labelle spoke about in our first plenary session. There always has to be a balance between what is open and what is not open. Question is, which is which? So the Freedom of Information Law has been in existence for just over 5 years now. We have had government-wide something in excess of 3,000 requests. And our own office, the Information Commissioner's Office, has heard some 140 to 150 appeals. And I'll come back to that as well. Now, I assume that all of you have some sense of what freedom of information is and access to information is. And I'm just going to talk about a few practical, specific arrangements that we have made in the Cayman Islands FOI law that are perhaps a little different from some other jurisdictions, or at least most other jurisdictions. There's about 4 or 5 of those. The first thing that differs in our FOI law compared to other similar laws internationally is that we have something called an information manager in every public authority. It's not just the public authority that is responsible for responding to requests, but there is actually a person, a role recognized. This is a person who is trained, and that's a person who knows the law in each public authority and is responsible for responding. Now, that may seem like a mere sort of practical issue, but I think it goes deeper than that, because if you have a decentralized model of applying the legislation, you are more likely to be successful in attaining some of the broader goals that you're setting with FOI. FOI is not just about responding to a request, it is also about changing government. It's about changing the culture that exists in government. And as you noticed in that statement of objects of the FOI law, it puts the default very clearly on openness. The exception is to keep information from being accessible. And that's the exact opposite of the way things used to be, and the way things still are in many people's minds, namely that everything is secret unless you have a very good reason why you need it. And so that's quite a different approach. Now, that change of culture is more likely to succeed if you decentralize your implementation. And so that's what we have done, and we've done that very carefully. The second point that I think puts us in a slightly different framework than perhaps other countries, we have some elements of data protection in our legislation, in our freedom of information legislation, because the Cayman Islands right now doesn't have data protection legislation, but we have a definition, therefore, of what is personal information, but it is very progressive, I would say, because it excludes certain information about public officials. Public officers have different personal information than the general public, or than the people that are mentioned in the government records. So anything, essentially, I'm just going to not quite read it, but essentially, where an individual occupies or has occupied a position in a public authority, the name of that individual, information relating to the position or functions, and the terms upon which the individual occupies that position are excluded from personal information. And this may seem very, very logical, but you would be surprised how many cases we see where, for instance, the names of public officials have been removed from board minutes, government board minutes. Well, these names are not personal information, so they should not be removed. They should be revealed. And I think that's another thing where we are slightly different from other FOI legislation. Thirdly, as a small society in the Cayman Islands, there is always a risk that there would be retribution, or that people are fearful of asking questions. And Cayman is very small, as are many places around the Caribbean and around the world. And we therefore allow the use of a pseudonym when somebody requests information, and that's very unusual. In practical terms, in the UK, for instance, if you call yourself John Smith, nobody's going to question that. That's similar to a pseudonym. But in our law, it's actually quite explicitly allowed. You don't have to give your real name. Now, that's a little different, of course, when you ask for your own personal information, because then, of course, you do have to prove who you are. But as a general, in terms of a general request, that's an important point, I think. The fourth point is that, and we're not entirely different from other jurisdictions, but we are different from some. Our enforcement model is a very strong one. We have an information commissioner with the power to issue binding orders, and that is a model I think that is absolutely necessary. I don't think making a recommendation would change anybody's mind. I think there have to be real powers behind the enforcement of access to information legislation. And that is also combined with very wide investigative powers. And of course, the Information Commissioner is recognized as being independent and impartial. And the fifth point where we are a little bit different, I mentioned this before, is the fact that our legislation focuses on records, not on information. This was done on purpose. And the reason is this. If a requester asks for certain information and the government entity, in our case the information manager, simply responds by saying, this is your answer, what proof does the requester really have that this is correct? And we wanted to therefore go one step further and give the applicant a right to see the source record. That is not always simple. You know, a record may not be simply a piece of paper, obviously. It could be a database and so on. So there are issues around that. But I think it is important that there is that extra step of accountability that we have recognized in our legislation. FOI in the Cayman Islands is seen by some as a model for the region, and I think it is a model that is working quite well. And obviously, every place has its own specific conditions that would have to be met, and not all of these solutions that I propose, that I've talked about here, might work everywhere. But I think it is, these are the solutions that worked in Cayman, and everybody will have to sort out their own, obviously. A few words on the two things, basically. When we talk about accountability and we talk about transparency, we're talking about recorded information. And very often in the Caribbean in general, and also in the Cayman Islands government, information and records management is not taken seriously. Information is an important, if not the most important asset of government, and it deserves to be properly managed and created. If a record is not created in the first place, there will not be any accountability because nobody will be able to check the facts. And access will be purely theoretical. And secondly, perhaps another word of criticism, if I may, towards the way things are going right now, is that, yes, it's good to have 3,000 plus FOI requests, but is it really such a good thing to have many FOI requests? Would it not be better for government to be proactive and to putting information out there and rather not force people to use this mechanism to actually gain access to information that really is theirs and should be open in the first place? Thank you very much.
Thank you, Jan. We appreciate that. I'll now call on Mr. Leonard Ebanks from the Anti-Corruption Commission to make his presentation.
Thank you, Mr. Chairman, members of the head table, distinguished guests, ladies and gentlemen. We are one of the institutions supporting democracy in the quest for a corruption-free Cayman Islands. Integrity, transparency, accountability, and good governance are terms used nowadays to describe the political and public environments that countries around the world strive to attain. They do so to work towards becoming and remaining corruption-free. Corruption is neither unique nor intrinsic to any one jurisdiction, the Cayman Islands included. Countries around the world continue to encounter this problem in one form or another. According to Transparency International, corruption is the abuse of entrusted power for private gain. Corruption is a global problem which can have far-reaching implications. Politically, it is a major obstacle to democracy and the rule of law. Economically, it depletes a country's national wealth. Socially, it undermines the trust in the system and leadership. And environmentally, it works to exploit natural resources. At the 4th Annual International Association of Anti-Corruption Authorities conference in Macau, China, Professor Paulo Lorio, chairman of Advocates Sans Frontières, my French is not so good, Advocates Without Borders, explored from an academic perspective the importance of teaching ethics in public life. He expressed the opinion that corruption in all its forms was the modern sin of society, which in turn destroys the soul of a country. Years ago, during what might have been referred to as the good old days, the who you know principle was the standard, the norm. There has, however, been a steady change in the global attitude towards corruption, with increased efforts being directed at the fight through enacting of legislation, education, and preventative initiatives, and a reduced level of tolerance for those who use their public office for private gain. The Cayman Islands are a signatory to the OECD Convention on Combating Bribery of Foreign Public Officials in International Business Transactions and the United Nations Convention Against Corrupt Practices. In 2010, the Anti-Corruption Law, ACL of 2008, came into effect, which created the Anti-Corruption Commission, the ACC. The ACC is one of the key guardians of the integrity of the public administration. It is empowered to stimulate and ensure accountability and public confidence in how the government and its agencies conduct its business and affairs. Its broad-reaching powers allows it to investigate reports of corruption, liaise with overseas anti-corruption authorities, and obtain court orders to freeze the assets of those suspected of committing corruption offenses. Or functions and duties. Under the law, the primary functions and duties of the ACC are to receive and consider any report of the commission of a corruption offense and, subject to the law, investigate such report. The ACC may receive and, as permitted, request, analyze, and disseminate disclosures of any information concerning corruption offenses under the law or suspected offenses or required by law in order to counter corruption. The ACC may also investigate any suspected offense under the law, any suspected attempt or conspiracy to commit an offense under the law, and do anything else that is required or authorized to do under the law or any other law which is necessary for the achieving the purpose of anti-corruption. In order to fulfill its functions and duties, the law also grants the ACC with a vast amount of power to aid in its anti-corruption mandate. There are 15 offenses under the law. In accordance with Section 10 to 25 of the Anti-Corruption Law 2008, the ACC may receive reports of allegations of the following 15 offenses: bribery of public officers and members of the Legislative Assembly, frauds on the government, contractors subscribing to election fund, breach of trust by public officer or by a member of the Legislative Assembly, selling or purchasing an office, influencing or negotiating appointments or dealing in offices, false claims by public officers, abuse of office, false certificates by public officers or by members of the Legislative Assembly, conflicts of interest, and that's been popular these days, failure of a public officer and member of the Legislative Assembly to whom a bribe is offered to report such offerings, secret commissions, bribing of a foreign public officer, facilitating payments, and false statements to the Commission. The membership of the ACC consists of the Commissioner of Police, the Complaints Commissioner, and the Auditor General, and 2 additional members appointed by the Governor. Currently, those 2 additional members are Sir Peter Allen and myself. The independence of the ACC is crucial to its ability to perform its functions. Only the Governor has the power to give directions to the ACC with respect to policy followed in exercise of and its performance of its functions in relation to matters appearing to the Governor to concern the public interest. She is also responsible for the general oversight of the anti-corruption policy of the government, B, overseeing and inspecting the work of the Commission, reviewing annual reports submitted by the Commission, promoting effective collaboration between regulators and law enforcement agencies, and monitoring interaction and cooperation with overseas anti-corruption authorities. Public officers may incur criminal liability for corruption as follows. Those directly involved, an individual who is directly involved in committing a corruption offense in accordance with the law. Those indirectly involved, an individual may be liable for a corruption offense where he or she is indirectly involved in committing the offense. For example, an individual may be liable where he has used another person or organization to commit the corrupt act on his behalf. And importantly as well, failure to act. An individual may be liable for a corruption offense even where he or she was not directly involved in committing the offense, but willfully turned a blind eye to it. Such liability may arise where, for example, a chief officer suspects that the ministry or portfolio's employees may be paying or taking bribes on a project, but takes no action to prevent them from doing so, or by failing to report the matter to the Anti-Corruption Commission or a police officer. It also covers aiding and abetting. An individual may also be liable for aiding and abetting where he has aided or assisted in the committing of the offense. For example, a public officer who drafts an agreement or contract in an attempt to conceal a corrupt act, or an accountant who implements a corrupt payment system for his or her financial gain. Arguably, one of the more important features of the ACC is its ability to take complaints from the public. As such, the anti-corruption law creates a duty to report corruption. Failure to report known or suspected corruption to the ACC or to the Royal Cayman Islands Police Service can constitute an offense on your part. Section 21, a public officer or a member of the Legislative Assembly to whom any loan, reward, advantage, or any benefit is given, promised, or offered in contravention of any provision of the anti-corruption law shall report to the Commission or the police constable such loan, reward, advantage, or other benefit, together with the name, if known, of the person who gave, promised, or offered such a loan, reward, advantage, or other benefit to him. And Section 23, a person from whom any loan, reward, or other advantage, benefit has been solicited or obtained, or an attempt has been made to obtain such a loan, reward, advantage, or any other benefit in contravention of any provision of this law, shall at the earliest opportunity thereafter report such soliciting in obtaining of an attempt to obtain the loan, reward, advantage, or any other benefit, together with the full and true description, if known, to the name of the person who solicited or obtained the loan, reward, advantage, or any benefit from him to the Commission. And you shall see that the operative word in this legislation is shall. It doesn't say may, shall. So you have a duty to report, and if you do not report, and we find out about it afterwards, come back to you, you're liable. There are other provisions, I won't go through all of them, but I know time is moving on, but we have a vast amount of power. Also, being an agent demands, accepts, or offers, or agrees to accept from any person any loan, reward, advantage, or any benefit in consideration for doing or forbearing to do, or for having done, forborne to do, any act relating to the affairs or business of his principal, or for showing or forbearing to show favor or disfavor to any person with relation to the affairs or business of his principal. Also, if you intend to deceive, there are penalties there in which the principal has an interest that contains any statement of false that is intended to mislead the principal, and so on. Persons who fail to comply with these duties, as I said before, commits an offense and are liable on summary conviction to a fine of 10 to 20,000, and that's Cayman dollars, by the way, and imprisonment of between 2 to 5 years, or both. The ACC accepts complaints in person, by email, or by phone. It has a confidential reporting phone line and a website where persons can access more information. In conclusion, it is vital in a democratic country that there are checks and balances provided to keep an accountable and transparent public service. It is the goal of the ACC to not only shed light on corruption and bring justice to the people of the Cayman Islands, but to hopefully, by our very existence, prevent corruption as well. This can only be done through a symbiotic relationship between government and the citizens of the Cayman Islands. The ACC will continue to look to you to do your part, report corruption, ask questions, provide evidence, statements, and other information to support claims of corruption, and be willing to take a stand against those who display corrupt practices and behavior. I thank you for your attention.
Thank you, Mr. Ebanks, for that presentation. Obviously, a very significant component of our system. I will now call on Mr. Alistair Walters from the Human Rights Commission. Alistair,
thank you, Mr. Chairman, members of the head table, ladies and gentlemen, good evening. As the Chairman said, I'm here to explain a bit about the workings of the Human Rights Commission. On the 6th of November 2012 and 2013, Part 1 of the 2009 Constitution was implemented in the Cayman Islands. Part 1 of the Constitution contains the Bill of Rights, Freedoms and Responsibilities, which is a cornerstone of democracy in the Cayman Islands. Human rights are the essential rights and freedoms that belong to all individuals, regardless of their nationality, citizenship, age, gender, or social status. These rights are considered central to maintaining a fair and just society. Fundamentally, human rights are about the balance of rights, freedoms, and responsibilities, treating individuals fairly, with dignity and respect, while still safeguarding the rights of the wider community. The HRC was established by Section 116 of the Constitution. It consists of a chairman and 4 other members appointed by the Governor, acting after consultation with the Premier and the Leader of the Opposition, and at least 2 members of the Commission must be experienced lawyers. The HRC works continuously to promote, protect and preserve human rights in the Cayman Islands. It seeks to ensure the observance and awareness of human rights, investigates complaints about potential breaches of human rights by public officials, provides a forum for mediation or conciliation, gives advice and guidance to inquirers of all kinds in relation to their human rights, and publishes reports on its own initiatives on human rights issues. The HRC cannot represent or provide representation to parties, act in a judicial capacity, or make binding determinations as to whether any right or freedom contained in the Bill of Rights or any international human rights treaty or instrument has been breached, or compel any person to do anything against his or her will. The Commission can, however, address recommendations to any public officials following an investigation, and any public official to whom the Commission does address a recommendation must respond in writing within a reasonable time. Human rights are only applied vertically in the Cayman Islands, which means that the rights listed in the Bill of Rights can only be enforced against the government and not against private individuals. Ensuring that they're upheld, therefore, becomes a responsibility for public officials. They have a duty under the Constitution to ensure that all acts they carry out and decisions they take are carried out or made in a lawful, rational, proportionate and procedurally fair manner in accordance with the Bill of Rights. The consequences of corrupt governance are multiple and touch on all human rights: civil, political, economic, social and cultural. The corrupt management of public resources compromises the government's ability to deliver an array of services, including health, educational and welfare services, which are essential for the realization of economic, social and cultural rights. Human rights principles and institutions are therefore essential components of successful and sustainable anti-corruption strategies. As you'll know, corruption is an abuse of power that tends to benefit a narrow elite at the expense of those who are less able to defend their rights and interests. As a result, all forms of corruption tend either directly, indirectly or remotely to violate human rights. Conversely, wherever human rights are not protected, corruption is likely to flourish. In the absence of human rights like freedom of expression and assembly, or access to information and education is restricted, it's extremely difficult to hold government officials to account, which allows corruption more room to spread feeling. Where corruption is prevalent, it is also hard to promote human rights. Anti-corruption human rights organizations therefore have a common interest in working together and sharing methods, standards and tools that will make their work more effective and mutually reinforcing. Particular attention needs to be given to the impact of corruption on disadvantaged and disempowered groups such as migrant workers, persons with disabilities, refugees, and in broader terms, all those who are poor. Often these groups are excluded from full participation in public debates and discussions and from access to social policies and services. Again, as you'll be aware, corruption is a profoundly social activity shaped by cultural notions of power, privilege and social status. For this reason, anti-corruption policies should not treat corruption as if it were composed of isolated and opportunistic acts of selfishness. It is rather a social expression of power that permits certain people, primarily government officials and business leaders, to control and oppress others economically, politically and culturally. A human rights analysis throws light on the power relations in a society because it pays particular attention to discrimination, equity, and the removal of economic, legal and political obstacles that prevent marginalized groups from enjoying their rights. As a result, a human rights analysis can contribute directly to the design and implementation of anti-corruption policies. The HRC exists to safeguard the rights, freedoms and responsibilities listed in Part 1 of the Constitution for the people of the Cayman Islands, and assists in the quest for a corruption-free Cayman Islands by promoting transparency and accountability among our public officials. Through its work, the HRC encourages public officials to adhere to principles which strengthen democracy and safeguard against corruption. So the HRC would encourage you to take time to become familiar with Part 1 of the Constitution. Education and awareness are crucial defence mechanisms in the fight against corruption. And I would particularly refer you to the Commission's website, which has a lot of information about the work of the Commission, its reports, its minutes of its meetings, and is a good source of information. And on that note, I will close and hand over to the next speaker. Thank you, Mr. Chairman.
Thank you, sir. Most grateful. We'll now call on Mr. Alistair Swarbrick to speak to us from the Auditor General's office.
Cheers, Donny. Thank you, Donny. Good evening, ladies and gentlemen. It's a pleasure to be here with you this evening and involved in this final plenary session of what I am sure you will agree has been a truly excellent conference, tackling issues that are of fundamental importance to the region and internationally. This evening I've been asked to consider if Cayman could be conceived as a model for anti-corruption. Within this, to consider specifically the role of my office and how it fits into the anti-corruption framework. As many will be aware, apart from being the Auditor General, I am also a member of the Anti-Corruption Commission, but the focus of my presentation will be solely on my role as the Auditor General and that of my office. The role of the Office of the Auditor General and public sector audit in general is something that I am passionate about. I believe it can play a key role in democratic societies to enable positive change and deliver efficient and effective services that deliver better outcomes for citizens. The Audit Office in Cayman has been in existence for just over 30 years, and in that time it has changed and developed significantly. We still have some challenges in effectively delivering our role and mandate. But first, I will discuss the important role that the Audit Office has in helping to curb corruption and how it fits into the anti-corruption framework here in Cayman. If you look at the Constitution and the laws that provide my office with its powers, you will not find any word of or mention of the word corruption or fraud. The role as specified talks about the audit of accounts, audits or investigations of financial management, the efficiency, economy and effectiveness of government, and the reporting the results of the audits. However, if you step back and examine the broad legislative mandate provided to the Audit Office to examine how government and the public service manage and use public resources, you can see that the Audit Office has a significant role to play in helping to prevent and deter corruption. In essence, our role and the audits we undertake are about promoting an environment of good governance which provides accountability and transparency in the use of public resources, in particular through fostering strong financial management based on reliable and sufficient and timely financial reporting and effective internal control systems. Therefore, as an agency responsible for auditing government income and expenditure, the Audit Office acts as a watchdog over the financial integrity of government, the credibility of the reported financial information, and whether a government achieves value for money for the resources used. Therefore, our primary role in the battle against waste, abuse of public funds, and thus corruption, is to aid its prevention and to deter its occurrence through supporting an environment that limits the opportunity for acts of corruption and creating a climate of good governance. People often assume that one of our main responsibilities is to actually detect and investigate cases of fraud and corruption. Whilst I would not want to understate our role, I think it is important to recognize that as auditors, it is not one of our primary responsibilities. It's getting late, I'm starting to stutter now. However, the nature of our remit as public sector auditors and how we plan and carry out our audits means that we are likely to identify potential cases of fraud and corruption. For instance, in the planning of our audits, from the strategic level of deciding which performance audits to undertake to the individual audits of entity financial statements, the risk of fraud and corruption is one of a number of important factors in determining the audits we conduct and the detailed work that we carry out within those audits, and is in fact something that we are required to consider as part of our professional standards. Also, the fact that we look to obtain public input to our audit program and are a mechanism for the public to complain about how government has used resources means that we're likely to come across issues which may potentially point to corruption or fraud. Whilst we will potentially detect fraud and corruption through our work, and it will probably come as no surprise to many that we have identified a number of cases, or potential cases, our powers and skills to investigate them fully are limited. For example, our powers do not extend to examining the activities or personal records of citizens or private companies. Therefore, whilst we will progress our work to a stage where we are content there is reasonable and sufficient evidence to confirm our initial findings, and that in our view there is a potential fraud or corruption, we will pass the information over to the appropriate law enforcement agency to investigate the matter fully, either the Anti-Corruption Commission or the Financial Crimes Unit of the RCIPS. It is important to understand that we have a duty as auditors under our professional and ethical standards to bring instances of corruption and fraud to the attention of the relevant law enforcement agency. In addition, under the anti-corruption law, we also have a legal responsibility as public servants to bring any instances of suspected corruption to the attention of the Anti-Corruption Commission. Our role in Cayman, with respect to curbing corruption, is broadly similar to most public sector audit institutions operating under a Westminster style of government, and to a large degree internationally. Although colleagues in some Francophone and Latin countries do have broader powers to administer sanctions. Is the Cayman anti-corruption model worthy of emulation by other societies? Answering that question is not straightforward. In Cayman, we have significant legislative framework that, whilst not perfect, has the potential to provide an effective basis for anti-corruption institutions and activities. However, at a practical level, it is highly dependent on the strength of the oversight institutions and their capacity to effectively discharge their roles in a coordinated fashion to effectively support an environment that limits the opportunities for corruption. Considering the institutional strength of my own office and its capacity, this is derived mainly from our independence from government in terms of the discretion to determine the work we undertake and the resourcing of that work, the clear and broad legislative mandate, and the ability to report publicly on the outcomes of our audits. The legislative mandate of my office generally provides us with appropriate and board-based powers to audit across the spectrum of government activities. There is one area where it could be strengthened in regards to following the public dollar to non-governmental organisations, which is a function of public services and projects increasingly being delivered by third parties. But that does not ultimately compromise our ability to undertake core audit work around how government manages its resources. The most significant issue for my office, though, is around its independence. Whilst my role personally is constitutionally independent, my office is still legally part of the core government, with control over finance and certain aspects of staffing exercised over it by other parts of government, parts that we audit. Therefore fundamentally compromising our independence and enabling government to potentially constrain the work we do by constraining our resources. There are also risks and pressures around our ability to publicly report. Whilst we have, as an office, in the last 6 to 7 years been able to effectively report our findings in public, there have been challenges to this, and there is a clear need to strengthen legislation to ensure that we can publicly and transparently report our findings as we consider appropriate. The ability to effectively report the results of our audits to the legislature and the wider community is essential. If this ability is constrained, our ability to carry out our mandate and support the prevention and deterrence of corruption is undermined. The final issue is the need for effective relationships with other institutions and agencies. The key relationship for my office is the relationship with the Public Accounts Committee, which can provide an effective mechanism for holding government publicly accountable and act as a force for the implementation of recommendations. This can be a very powerful driver for improvement if it is robust. The role of PAC in Cayman has not been smooth, and being brutally honest, the politics has often got in the way of it effectively discharging its role, although I would indicate that I feel we are turning a corner in this regard. With respect to the relationships with investigating agencies, the current model, in my view, clearly supports an effective working relationship with the requirement for the Auditor General and the Complaints Commissioner to sit on the Anti-Corruption Commission. It is maybe a function of a small state and the limited resources available, but my personal opinion is that the current setup of the Anti-Corruption Commission enables my office to work in a more coordinated fashion with investigators on matters that impact both institutions. So in considering whether the model is worthy of emulation, we need to consider whether the framework is compromised by the institutional strength of the key institutions that support it. As Minister Ngozi from Nigeria clearly said in her address yesterday morning, the key to a robust anti-corruption regime is the strength of the institutions that support it. Looking regionally across the Caribbean, many of my Auditor General colleagues look a little enviously at the framework and the institutional strength we have here in Cayman. But when I consider the position in Cayman against the broader international standards and institutions outside of the region, there are still challenges and constraints on my office's institutional strength and capacity. In conclusion, I would suggest that the framework we have in place in Cayman has the key building blocks in place, and there are lessons that we can share with our other jurisdictions, as my office already does. However, we are still on a path of continuous improvement, and there is still work to be done so that our institutions have the strength to help and deliver and support the legislative framework, and therefore ensure that we build an environment which prevents and deters corruption. Thank you very much.
Thank you, Alistair. I'm most grateful for that oversight. I now call on Mr. Will Pinot from the Constitution Commission.
Thank you, Mr. Chair. Good evening, ladies and gentlemen. I'm delighted that you stayed around for this last session of the conference. I know you're so eager to ask some questions when we move to question time in a few minutes. I'll keep my comments brief, but I want to provide you with some background about the Constitutional Commission, which obviously I regard as an important part of our Constitution. A country's constitution is its fundamental underlying framework that establishes both the government's power and the fundamental rights belonging to all people who reside within its borders. The Constitution is the most vital document seeking to outline the way a modern country operates. It serves as a social contract between the government and the people. It offers checks and balances on the way people with authority rule, and it embodies the shared goals and ambitions of a society. The Cayman Islands obtained its first constitution 55 years ago, on the 4th of July, 1959, at a time when these islands were still a dependency of Jamaica. In 1972, that constitution was replaced with a more advanced document which gave the people of the Cayman Islands more control over the governance of its affairs. And as Cayman's growth and development continued, after 10 years of discussions, national debate, and considerable controversy, a historic referendum on 20th of May, 2009, Caymanians approved a new modern constitution to govern the affairs of the Cayman Islands. The Cayman Islands are a democratic set of islands founded on the values of human dignity, equality, and freedom. Our Constitution is the foundation on which our democracy is built and the ultimate embodiment of the rule of law within our land. It's a framework for our government and an instrument of protection for our rights, freedoms, and responsibilities. It promotes strength of our people and ensures government and public officials alike are held accountable to the highest standards. All who exercise authority in our islands do so pursuant to the Constitution and must do so in accordance with it. Through the introduction of a modern Bill of Rights, our new Constitution provides the means to protect the people of our islands against tyranny, corruption, and arbitrary actions by the government. It enables the people to take stand in our community on the issues important to them, the ideals they believe in, the things that make Cayman, Cayman. It is, in a sense, a living, breathing organism impacting every day of our lives, but yet is often unseen. As stated in the preamble, the people of the Cayman Islands, in developing our Constitution, recalled the events that shaped our history and made us what we are today. We acknowledge our distinct history, culture, and Christian heritage, and its enduring influence and contribution in shaping the spiritual, moral, and social values that have guided our development and brought peace, prosperity, and stability to these islands through the vision, forbearance, the leadership of the people, and their loyalty to Her Majesty the Queen. We affirmed, among other things, the Cayman Islands' intention to have an open, responsible, and accountable government, and an environment which fosters the highest standards of integrity in the dealings of the private and public sectors. Our Constitution ingrains the commitment of the people of the islands to work towards a jurisdiction that is free from crime, a jurisdiction that is indeed corruption-free. Because of its great importance, there needs to be a body or entity charged with ensuring that it is working as it was intended, that it is clear in its meaning and context, and that the citizens of the islands are made aware of its importance, and finally, that it is kept under review from time to time to address anomalies, errors and omissions, and the need for modernization. In the Cayman Islands, that body is the Constitutional Commission. Along with the other entities and commissions represented here today, the Constitutional Commission is considered an institution supporting democracy. These institutions were designed to increase public participation in government, decision-making, promote transparency and accountability by providing for more checks and balances on the exercise of executive authority, and ensure our people are served by persons of honesty and integrity. Comprising of 3 members, including David Rich, who serves as chair, Sarah Collins, and myself, the Constitutional Commission plays its part by discharging the following constitutional functions: advise the government on questions concerning constitutional status and development in the islands, publish reports, discussion papers, information papers, and other documents on constitutional matters affecting our islands, promote understanding and awareness of the Constitution and its values, and exercise such other functions as may be prescribed by a law enacted by the legislature. To perform effectively, the Commission must, of necessity, rely upon a positive, synergistic relationship with the government, a relationship that must be both engaging and proactive. The Constitutional Commission remains committed to promoting understanding and awareness of the Constitution and its values, and an understanding of the relationship between the Constitution and governance of the Cayman Islands government. We have an obligation, as individuals whom this Constitution affects, to educate ourselves on the contents of our Constitution, and you can do so by visiting our website, knowyourconstitution.ky. The Constitutional Commission continues to support the other institutions supporting democracy and remains committed to working towards the quest for a corruption-free Cayman Islands. Thank you for your attention.
Thank you, Will. And now our final presenter, who hope has had a chance to catch a breath after doing back-to-back sessions. I'll call on Ms. Nicola Williams from the Office of the Complaints Commissioner.
Thank you, Chair, for your gracious introduction. Good evening, ladies and gentlemen. It's always difficult to be the last one to speak, because particularly when I know there's food at the back. And I've seen the pan players have come in, and that is a potential distraction. But I hope you will bear with me for at least the next 10 minutes or so, and then perhaps for questions afterwards, and then you'll be free to enjoy both those things. Thank you for staying this late to hear all of us. I feel privileged to be in such esteemed company as my plenary colleagues, and I'm going to talk to you about my office, the Complaints Commission, the Office of the Complaints Commission, and how we are, as an institution supporting democracy, the role that we play within the quest for a corruption-free Cayman Islands. In fact, it was going to be another member of my staff who was going to be giving this presentation, so I'm actually, even though I'm the boss, I'm actually standing in for another member of staff. I'm also a member of the Anti-Corruption Commission. It's a commission that is five-fold, or has 5 members of it, and you're privileged to have 3 of the 5 members here tonight. So some of my talk will dovetail into that, but mostly I will be speaking about my primary office as Complaints Commissioner, what we do and how that plays into creating the Cayman Islands that we all want, which is free from corruption. Now these words, confidentiality, integrity, and independence, those 3 words effectively encapsulate what the OCC is about. And in fact, on all our publications now, you will find that as a byline, and that really summarizes what the office is about. For those of you who don't already know, we were established as an independent office in July 2004 to encourage government departments and agencies to better serve the public. And so, in fact, this July will be the 10th anniversary of the office. The overarching aim of the office is to investigate complaints against government in a fair, transparent, and independent manner. And I am only the second complaints commissioner, the first being Dr. John Epp, and all complaints commissioners are appointed by the governor. In terms of a brief overview of my office, the legislation that underpins what we do, the originating legislation, is the Complaints Commissioner Law, which is now in its 2006 revision. Originally, it was the 2004 revision, and the Complaints Commissioner Regulations, also 2006. But since 2009, we have also been enshrined in the Constitution, Section 120 of the 2009 Constitution, and we are therefore clearly recognized as an institution supporting democracy. So the independence and the political neutrality of the post of Complaints Commissioner has therefore been further emphasized by thus being enshrined in the Constitution. We are responsible for investigating, investigating, in fact, 93 government entities, complaints against those entities, to see whether those complaints are valid and to make recommendations if they are valid. Now, in the 20 months from the 1st of July 2012 to the end of February this year, we have produced 2 own motion investigation reports, 2 special reports, on top of our, if you like, our day-to-day bread and butter mandate, which is to deal with inquiries, complaints, and investigations from members of the public. Those can be by people presenting themselves to the office or doing it via letter in written form. We also deal with quarterly reporting and monitoring of internal complaints processes in government, and we monitor outstanding recommendations. But what do we do? Well, the primary functions of the office are to investigate, to recommend, and to report. Now, we investigate any complaints made in writing that fall within the scope of our law. And we also investigate matters, or I, as Commissioner, or any person holding this office, can investigate matters of their own motion, which, in my opinion, would be in the best interest of the public and affecting a large group of residents. So, for example, the 3 reports that have been done since I've been in post have been concerning pensions, health and safety in the construction industry, and the most recent one, which was only put in the public domain the end of last week, whether or not there are adequate protections for whistleblowers within the Cayman Islands government. Now, once we do investigations, we make recommendations. If there are failings or maladministration against government, and certainly not every complaint is bona fide, and we can certainly weed those out and make appropriate findings there. But where maladministration has been found, the office makes recommendations for actions to be taken by that particular entity. Now, these can arise directly from the complaint, or it can be an ancillary matter, an additional matter arising out of the original complaint. For example, we may think that a particular law should be amended or a rule should be changed. For example, the last 2 reports have both made, last 3 reports, I beg your pardon, have all made recommendations as to legislative changes. So we investigate, we recommend, and we also report. We do a number of reports. First of all, we inform the government entity of the result of any investigation if injustice has been sustained due to that entity's actions. We also do special reports and own motion reports, which are tabled in the Legislative Assembly and then put in the public domain. Now, in case I haven't convinced you as to why a Complaints Commissioner's Office is needed, it's really for these 2 reasons: so that we can conduct fair, independent, and thorough investigations, including own motion investigations, and we can encourage and ensure government transparency, because an open and transparent government is key to a corruption-free Cayman Islands. In fact, of the 6 principles of good administration, the 3rd principle about being open and accountable is very much part of open government, which has been endorsed both by the Deputy Governor as head of the Civil Service and also by the Honourable Premier. As well as the laws that I've already spoken about that apply to our office, there is also an additional law which applies not just to us, but applies to government, and I think is actually could be key to moving towards a corruption-free Cayman Islands, which is the part of the Constitution that deals with lawful administrative action. And we encourage compliance with this, and that effectively says that all decisions and acts of public officials must be lawful, rational, proportionate, and procedurally fair, and that every person whose interests have been adversely affected by such a decision or act has the right to request and be given written reasons for that decision or act. If you have to put in writing your reasons for doing something, it can be a big deterrent to someone who wants to act in a corrupt way, because they'll have to explain it and then they'll have to justify it, and there's a permanent record of it. So in conclusion, with increased awareness by government that fearless and rigorous investigations assist, not hinders, good governance, we actually now have far more supporters than detractors. There are people who probably still think that our office is there to make life difficult for civil servants, but we very much recognize, A, that civil servants don't come to work to make people's lives difficult, and B, that we are an institution supporting democracy and therefore have a key role to play in the public life of the Cayman Islands. And very finally, loss of public confidence is fatal to good governance. If the general public has no confidence in good governance as a concept or in its government, particularly because of corruption, whether perceived or actual, that is absolutely fatal. One of the things that we want to do as our office is to collectively raise the public trust and confidence within government. Public trust and confidence in our office has raised from 30% when I joined the organization to 75% at the end of last year. But we will not consider our work has been done until the public trust and confidence level in government as a whole has been raised to at least that level, and as we move on towards trying to create a corruption-free Cayman Islands. Thank you very much.
Thank you very much, Nicola. Well, that concludes our presentations. We'll allow questions for about 10 minutes. I know there's some other activities to follow. So if you have something that you'd like to ask, some enlightenment you'd like to gain, the floor is open. Dr. Monroe. Is there a mic around? Mr. Adams, go. It's on its way.
Thank you, Monica. Just one question in relation to the Anti-Corruption Commission. How many times have you actually instituted proceedings in relation to offenses? It's one thing to know the law, it's another thing to have some idea of how far it has been applied.
The very nature of our business is that we don't really come out and say what we are doing. But if you go on our website, you will see some minutes. They are not up to the date, as I would say. They may be a couple of months old, but you would see some minutes there which give you some indication. But having said that, the Commission has not been sleeping.
I see a hand in the back, Mr. Billy.
Thank you very much. I enjoyed the presentations from all of you. The question I have revolves around the independence of the guardians of democracy, integrity, accountability, honesty, and that term, good governance, when in fact good governance is not controlled by the Cayman Islands government, it is controlled by the United Kingdom government. Because in our Cayman Islands Constitution, at the end, in Article 125, power reserved to Her Majesty, it says, there is reserved to Her Majesty full power to make laws for the peace, order, and good government of the Cayman Islands. Now, we have seen the Auditor General, when he went in the past at the government, we saw what happened to him with his contract. The present one is doing a wonderful job. I think they got a surprise. They thought that they were getting rid of trouble, but they got more. That is not trouble, but somebody actually doing his job. The previous Auditor General, and before him, we didn't even know that there was an Auditor General, and he didn't do his job. He just collected a salary. Now we have a Complaints Commissioner, that there's questions over what will happen there. Again, she's doing her job, but government didn't really intend for this to be. We have the Anti-Corruption Commission, which is not really a commission. It's underfunded, under-resourced, has no independence. And I'm wondering how much do we have control of good governance when, as a colony, the United Kingdom has full power? What can we do to really effect good governance? How can we appeal to the UK, where we want to have a good anti-corruption commission, we want to have a good Auditor General functioning, we want to have a good complaints commissioner, but then when the governor, who's responsible for the contract, can say your contract isn't renewed, what can we do about that?
Well, thank you for the presentation, Mr. Billy, and for having rounded it up to a question. I don't know if Will or anyone else would wish to challenge it or try to respond to you.
Challenge what?
To respond, I should say.
I'll respond to one specific point about tenure of office for Auditor Generals. A fundamental principle now being espoused is that Auditor Generals should have one term of office for a period of time which is sufficient for them to carry out their job effectively, efficiently, and robustly. International guidelines are that's between sort of 7 to 10 years for one term, so that they don't, if any longer, there are issues about whether they become compromised, their effectiveness gets diluted, and we've seen examples of that in jurisdictions where Auditor Generals have been able to continue on for 20, 25 years. So that is the international perspective of the appointment and security of tenure of Auditor Generals, and I think that's probably a reasonable context to think about the appointment for any of the oversight bodies in terms of their leaders and in turn to ensure their independence and that they don't get compromised by being in post for too long.
Thank you, Alistair. Any other questions?
Thank you. Billy's mentioned the United Kingdom. I'm from the United Kingdom, and I'm treated here so differently. I'm a resident, a legal resident here, but I'm treated so differently from a Caymanian who goes to the United Kingdom. Once a Caymanian is in the United Kingdom, as soon as they're registered, they get a vote. If they can get 10 people to support them, they can stand for the Parliament in Westminster. Here, you have no vote, you pay all your duties, all your rates, everything else, yet you have no say. Is there any thought of giving residents a vote, and not just Caymanians? It seems so unfair. It seems so against human rights, from my way of looking at it.
It's the immigration.
Thank you.
Well, we note your observation. I wouldn't expect that. I mean, obviously, the electoral process isn't within the remit of any of these agencies that you've heard from this evening. And so, you know, I think it's something that you're free obviously to express, and you're free to direct to those who hold elected office and who are responsible for electoral changes in electoral legislation. Any other questions? No, everyone's been intellectually drenched over the last 2 days. We thank you for being here at this hour on a Friday evening. We certainly hope that you've found the presentations enlightening. Trust that you've been able to get in much over the past 2 days, and invite you to stick around for the remaining wrap-up activities this evening. Thank you.